As president of the Bar Library, it's my pleasure this evening to institute the first in a series of Zoom events take place for a while at least of our regular program of lectures in the library. We're unable to provide our viewers with customary refreshments at the end of the lecture, but nonetheless, we hope the presentation is valuable and enjoyable. The subject of our presentation this evening is a rather timely one of impeachment, and our speaker, Ronald Weich, the Dean of the University Law School, knows a good deal about that. He has been Chief Executive and Chief Academic Officer of the law school since 2012. Prior to that, he was an Assistant Attorney General in the Department of Justice during the Obama administration. Before that, he was Chief Counsel to Senators Harry Reid and Edward Kennedy. And before that, he was a partner in the law firm Zuckerman Fader. He began his career as an assistant attorney in New York, graduate of Columbia and at the Yale Law School. He is very knowledgeable about these issues, particularly the issues from the White House. And we'll proceed to hear his remarks. I may then make a few comments, and then we will throw the proceeding open to questions from the audience, which will be forwarded by email. So now to Dean Weich.
Very good. Thank you very much, Mr. Liebman. I'm Ron Weich. I'm the Dean at the University of Baltimore School of Law, as Mr. Liebman said. Let me deal with a couple of logistical things first. On the screen that I'm seeing, Mr. Liebman's name appears as Francis Bennett, who is an individual who's helping Mr. Liebman with the technology, but that is George Liebman. I can attest to that. I'm glad to be with him. I'm also with my colleague, actually with two colleagues. I'm not sure if participants are seeing both of them, but one, C.J. Pippins, is Associate Director of the library, the Law Library at the University of Baltimore. And then my colleague, Christine Stutz, is our Communications Director. All of you participants are not on the screen, of course, but we hope this will be a dialogue. And so after I make some remarks and Mr. Liebman asks me some questions, feel free to put questions into the Q&A function of Zoom, and C.J. Pippins will field those questions and read them for me to respond to. So I'm very much looking forward to your input on what I hope will be an interesting and provocative discussion. Here's how we got here. You may wonder why we're here in the middle of a pandemic talking about impeachment. The Baltimore Bar Library, as you know, has a speaker series, and they invited me to be one of their speakers this year. And Mr. Liebman and his colleague, Joe Bennett, scheduled me to appear in March. And when we started talking, it was during the impeachment proceeding, the impeachment of President Trump. And I thought it would be interesting to reflect on that impeachment proceeding. I didn't know exactly how it would turn out, although I had a pretty good idea, as I will describe. And it seemed worthy of commentary. Of course, we needed to postpone that live appearance when we were struck by the coronavirus. That and many other live events were canceled. I was then contacted by the Bar Library and asked if I would want to do this virtual presentation. And I said, sure, I'd be very glad to do it, but I would need to update the topic. Simply referring and reflecting on impeachment at this moment seems a bit tone deaf, but I do think it's actually relevant to think about impeachment as we sit in the middle of this awful public health emergency that has already killed more than 60,000 Americans and many more around the world. And so I promise you, we'll tie those two concepts together. I very much regret that we're doing this remotely, only because I know that the Baltimore Bar Library is one of the most beautiful and majestic spaces in all of Baltimore. Mr. Liebman and his colleagues do a wonderful job of maintaining that beautiful facility. And I hope that when life returns to normal, we all have the opportunity to be back there and enjoy not just their food, but their fabulous setting, which is full of so much history itself. Impeachment, as you know, goes back many years. It really began in British history in the 14th century, and it is encompassed in our United States Constitution in several places. There have been relatively few impeachments through American history, and only 3 times have presidents been impeached. Richard Nixon was not impeached, that is to say, he was about to be impeached, and he then resigned. But Andrew Johnson in the 19th century, Bill Clinton several years ago, and most recently Donald Trump have been impeached. I found the impeachment proceeding related to President Trump to be deeply unsatisfying. I mean, on one level, it was very dramatic. And for constitutional scholars, for law professors, and certainly for law students, it was quite interesting to see the Constitution come to life in that way. And there was much pomp and kind of staging surrounding it. So we saw the procession of the articles of impeachment from the House across the Capitol Rotunda to the Senate chamber, the managers from the House carrying their articles. We had the summoning of the Chief Justice of the United States, John Roberts. And of course, this is such a rare moment when the Chief Justice presides in the Senate. It happened in the Clinton impeachment trial when William Rehnquist was Chief Justice, and now it happened with John Roberts. But putting aside the spectacle, I found the proceeding unsatisfactory in 2 ways. First of all, the procedures themselves, and then ultimately the fact that the outcome of this impeachment trial was utterly predictable, really preordained. I'll use the phrase designed to fail. Let me first talk about the procedures. This seemed meant to be a trial, I think, sort of. I'm sure many of the participants who are listening to this webcast, who would have attended a session at the Bar Library, are lawyers, many of them trial lawyers. And you know what a trial looks like. I have a pretty good idea of what a trial looks like. And this didn't look like a trial, and yet it had some elements that were trial-like. So the articles of impeachment seemed to be akin to the counts of an indictment. The House of Representatives in the impeachment scheme functions something like a grand jury that gathers enough evidence to move forward with a proceeding, and then they bring the articles, they bring the charges, as it were, to the body that's going to hear the charges, in this case, the Senate. But things got off the track very soon after the managers walked across the rotunda with those articles of impeachment, because there was never any serious trial. Instead, we had days and days of opening statements. Now, any of the trial lawyers who are listening to this know that would be completely ineffective if you spent days telling the jury what they were about to hear. But I don't fault the House managers for taking that time to give their opening statements. Rather, it was the procedures that were established unilaterally by the Senate majority, and specifically by Senate Majority Leader Mitch McConnell. He determined that there would be lengthy days of opening statements from both sides. There were also too many lawyers involved. None of us would expect to go to trial with 6 colleagues, as the House managers did, and a light number of defenders of the president, and each of them had to have their moment in the sun, but it became repetitive and ultimately unproductive. Then we had a series of questions from the senators that were delivered to and read by the Chief Justice of the United States. I found this very odd because we hadn't heard any evidence yet. And so the questions over the course of the days that we had questioning were more political statements than real probing into the evidence. And I found it, frankly, disrespectful to the Chief Justice and to the judicial branch that the Chief Justice was summoned from his chambers across the Capitol Plaza to sit in the Senate and be a clerk. I mean, he was reading questions. We could have found UB law students who would have been delighted to play that role, and they could have read the questions just as well. On 1 or 2 occasions, the Chief Justice declined to ask a question, and I suppose that was an exercise of judicial discretion. But remember that the rules in the Senate are such that if the Chief Justice made a ruling, and if a majority of the senators voted to overturn the ruling of the chair, they would have prevailed. So the Chief Justice was in a position to rule, but he could have been overruled by the Senate. And so that formulation I find disrespectful to the Chief Justice, disrespectful to the judiciary, and ultimately unproductive. And what were we missing in this trial? Let's see. No evidence. That was a problem. Now, of course, the House managers brought over their articles, and they had proceedings in the different House committees and were able to talk about the witnesses in those proceedings. But the evidence gathering there was truncated in large part because the president refused to cooperate. He did not make certain witnesses available. He threatened to invoke executive privilege at different times and did invoke executive privilege at other times. And he refused to honor subpoenas for documents. And so the fact-finding in the House does not suffice. We would have expected in a real trial to have the body subpoena material that would be needed for an evidentiary proceeding. But that didn't happen. Moreover, the Senate chamber, a place where I spent a good number of years of my professional life working for different senators, is no place to have a trial. Here's how this should have happened. If there were to be real fact-finding, the Senate should have appointed a committee of, say, 10 or 12 senators to hear evidence in a committee room and then bring a report to the full Senate. That's exactly how it happened in the late 80s when the House impeached 3 federal judges for various kinds of misconduct. One judge was Harry Claiborne from Nevada, Walter Nixon from Mississippi, and Alcee Hastings from the Southern District of Florida. Each of those judges was impeached by the House, and the Senate looked into the matter, conducted fact-finding and evidentiary hearings by committee. I worked for, at one time, a senator named Arlen Specter, who was the ranking Republican on the committee that heard evidence in the Alcee Hastings impeachment. This was a fascinating proceeding. Some of you may be familiar with it. Judge Hastings was accused of accepting a bribe. He was charged and tried criminally in federal court in Florida and was acquitted. And this is a whole other story about why that happened. The FBI didn't do such a good job in that case. But the House of Representatives decided there was enough evidence to impeach him, and it came to the Senate. And it was quite controversial. Senator Specter and the chairman of the committee that heard evidence, Senator Bingaman, decided that there was not sufficient evidence to remove Judge Hastings, but a majority of the Senate decided that there was, and it was, a supermajority of the Senate because of the 2/3 threshold that I'll talk about in a moment. And so Judge Hastings was removed from office by the Senate. In a very interesting afterward, Mr. Hastings, then no longer Judge Hastings, ran for Congress from Florida, and he won and has been a sitting member of Congress for more than 20 years ever since, sitting among many members who voted for his impeachment. So life takes some unpredicted turns. But that was a proceeding that was trial-like. And when the full Senate heard evidence, heard a report from the committee that had heard evidence, it was a very meaningful inquiry. That was not the case here. The fundamental problem, as I said earlier, is that the impeachment mechanism is too difficult to invoke. And really, the proceeding is designed to fail. Now, why do I say that? For 2 basic reasons. First of all, the standard to remove any civil officer of the United States, including the President of the United States, from his position, his or her position, is very high. It is, and this appears in Article 2, Section 4 of the Constitution, treason, bribery, or other high crimes and misdemeanors. Now, that phrase would lead you to believe that the president, in this case, must have committed a criminal act. In fact, if you look at the history of impeachment, going back to the British precedents in the 14th century and thereafter, you can see that the phrase high crimes and misdemeanor was not intended to be limited to criminal conduct. It certainly encompassed that, but it was meant to be broader. And when the framers of our Constitution were debating what standard should appear in the document, they debated a number of formulations. So James Madison originally proposed the phrase malpractice, a phrase that gives lawyers and doctors the chills. But here it would mean that the president failed to conduct himself according to a standard of care. That formulation was rejected. George Mason originally proposed the standard of maladministration. The president is just doing a really bad job. But the fear was that that kind of loose standard, effectively letting the president be subject to the whims of the Senate, would make the president too weak. And the framers, of course, were very much about checks and balances and finding the right balance among the branches of government. So ultimately, in a compromise with Alexander Hamilton, of Broadway musical fame, the framers come up with the phrase high crimes and misdemeanors. Hamilton, you'll recall from the musical, had been a great ally of George Washington, who was expected to be the first president. Hamilton favored a very strong presidency. If he had his way, it would have been a presidency for life. But he compromised with those who wanted more accountability, and they ended up with the phrase high crimes and misdemeanors. As I say, it doesn't mean crimes, but it sounds to the modern ear as though it needs to be a crime, and that's exactly what President Trump's defenders argued, and that's what many senators based their vote on, that there wasn't a sufficient showing of a crime. But the killer is the threshold for removal, which is 2/3 of the Senate. This appears in Article 1, Section 3 of the Constitution. Well, 100 senators, 2/3 is 67, not happening. Certainly not in the current Senate, which is controlled by members of the president's party. But even in a different kind of Senate, we wouldn't see that many senators coming together. And in fact, the impeachment mechanism has not succeeded for a president, although it has succeeded, as I said, for some federal judges and for some other officers. I think the framers were too concerned about protecting the president and insufficiently concerned about what to do about a president who was not discharging his duties in a satisfactory manner. The framers could have looked to the constitutions of the states, the new states that comprised the United States at the time the Constitution was being formed. Of course, before the United States, we had the Confederates, the Articles of Confederation governed, but those early states had their own constitutions, and they generally provided for a simple majority vote by the legislature to remove the chief executive. I don't know if that's the right standard, the right threshold, but I do know that the framers set the standard too high. And in other respects, they created a very rigid system. Remember that the president is constitutionally entitled to a 4-year term. Again, this differs from the precedents in the states at the time of the framing of the Constitution, where the chief executive typically had a two-year term, or in some cases, a 1-year term. Now, I don't think we would want a 1-year presidency, but 4 years seems an awful long time if, under current circumstances, we have a president who does not command majority support. So this then interacts with other aspects of the Constitution that create the current problem. Remember, the Electoral College enables an individual to become president with less than majority support. Donald Trump obtained 3 million votes less than Hillary Clinton, but he won because he won sufficient Electoral College votes. He won certain swing states. This was true of George W. Bush as well, but the Bush presidency unfolded in a very different way. Although George W. Bush did not have a majority of the popular vote, he very quickly attained majority support as president and really stratospheric support after the 9/11 attacks. And over the course of his presidency, his popularity was up and down, but very often above 50%. Donald Trump, in contrast, has never on a single day of his presidency enjoyed the support of a majority of the American people. I want to hasten to say this is not a political event. I'm the dean of a state law school. I don't engage in politics anymore. I'm just observing facts. If you look at national polling, you'll see that Donald Trump has not enjoyed majority support. This is quite different to this rigid 4-year term, even for the possibility of an unpopular president, is quite different from European systems, for example, where a president without majority support might well lose a vote of no confidence in the parliament, or would lose coalition partners and have the government fail under that on that basis. But instead, we have a system where the president is virtually unremovable from office, and that is deeply disturbing. So now we come to the pandemic. Here we are in the middle of this awful public health emergency. I just completed teaching this semester a class on leadership. It was called Lawyers as Leaders, since I teach in a law school. And we studied different styles of leadership and attributes of leadership. But one thing that was consistent in the commentary and literature about leadership is that leaders must speak clearly and consistently and factually, especially at a time of crisis and disruption. And I would think that I'm not the only one who's concerned about the president's leadership at this time, not just some of the most disturbing recent aspects where he used about the possibility of injecting disinfectant to kill the coronavirus, but just generally his divisiveness, his ridicule of members of the opposite party, and his constant refrain that journalists who are, I think, performing heroically to deliver the facts to the American people are fake news, and he's constantly jousting with them. And so I find his leadership lacking, and yet here we are in this rigid system where the one opportunity there was to remove him was not an opportunity to remove him. And of course, I'm not suggesting now that he be impeached. There are 6 months left in the presidency, and we're going to see this through to the end, I think. But we do have to look at the Constitution. If you take a step back and look at the constitutional scheme, it's quite disturbing that there's no remedy for a presidency like this. And we can't find the remedy in the impeachment clauses, as we see. The 25th Amendment, which came much later, of course, in the 1960s, has its own supermajority threshold, so that's not getting us anywhere, and that's meant to be for where a president is physically or mentally unable to serve. We might think, should we amend the Constitution? But that provision of the Constitution itself has supermajority thresholds. And in fact, 2/3 of both houses would have to support a constitutional amendment. And then there's the possibility of a constitutional convention, which scares many of us because of its unpredictability. But even that can only happen if 2/3 of the states agree. So what can we do? I think the framers of the Constitution, brilliant men, all well-meaning, and I think their handiwork has largely proven to be brilliant. But in this respect, I think they fell short in that they left us only one mechanism, and it is the presidential election that will occur in November. And again, without being the least bit partisan or even political, I would simply say we need to take this occasion very seriously. Voter turnout in 2016 was 55% nationally. 55% of registered voters voted. That's disgraceful, I would suggest, in a democracy when this election is the only opportunity for passing on the administration or maladministration of this president. And I would encourage my fellow citizens to take this election very seriously. And certainly I would encourage everybody to register to vote and to vote, whether it's in person or by mail, if that's what the pandemic dictates. One way or another, we will have the opportunity to exercise the franchise, and we must do so. So I'll stop there and ask Mr. Liebman if he has any questions for me.
Yeah, definitely.
Encourage the audience to use the Q&A feature to line up questions that C.J. Pippins will ask me.
Let me give a somewhat radically perspective on this series of issues. George Mason's view of the proper impeachment clause quite clearly was not that of the framers of the Constitution. George Mason, you may recall, was one of 3 members of the Constitution Commission who refused to sign. He and Benjamin Franklin, in fact, had a deep fear of the federal executive and wanted a plural executive, Swiss model, council of 7 people, which has worked very well for Switzerland and might have gotten us into fewer wars if we adopted it. Because the one thing that does subordinates the importance of the individual ego. But we have what we have. And I don't think there's much doubt that what just happened was consistent with the history. And Chief Justice Rehnquist wrote a little book about impeachment in which he essentially applauded the result of the Andrew Johnson impeachment trial, and likewise the impeachment trial of Chief Justice Chase in the very early years of the Republic. Raoul Berger, very noted scholar, who's probably the most careful scholar, had a different conclusion. He thought the judgment in the Johnson case was a correct one, but he thought that Chase originally deserved to be removed from the bench. It's important to note, by the way, that if you had a lax or liberal standard for presidents, that would be more than a fortiori as to judges. Because judges not only would be subject to impeachment for high crimes and misdemeanors, but there's also the good behavior clause vote in favor of more liberal standard for judges. And yet there are those who feel very vehemently that it would be inappropriate judges removed too readily. It seems to me to decry the weakness of the impeachment law as a fundamental flaw in the Constitution and the cause of our present difficulties is to go at things from the wrong end. The cause and to say that the solution to that is in more democracy and higher voter turnout is also to misunderstand what the last four presidents of both parties, in my view, have been profoundly unsatisfactory reasons. But they all are product of one phenomenon, and that is the breakdown of the system of indirect election that more or less controlled the election of president roughly until the election of 1960. The advent of the direct primary totally changed the dynamic of presidential selection. And when the direct primary was in its infancy, William Howard Taft, vehement opponent of it, uttered some prophetic words. The convention will take the more moderate man, appealing to independent voters, not men of wealth and of activity and of little modesty, without real qualifications for office. His fear was of Donald Trump or someone like Donald Trump. And he was right. And if you look at the record of what's happened since the convention system was cast in discard, what you have had are a series of populist presidents, whether you like their politics or not. These are not people who would have been chosen by a convention of office holders of their party. No one thought that Bill Clinton and other obscure partners answered the nation's prayers. No one thought that Bush, with all his youthful problems, was a great statesman. No one thought that Barack Obama, who came out of nowhere, was, and certainly no one thought that Donald Trump was another Charles Evans Hughes, William Howard, Franklin Roosevelt, even Adlai Stevenson. And the cure, it seems to me, for the problems we've got is not found in the pie in the sky of constitutional amendment. It's found in something that's within the power of the National Committee of both political parties to restore the National Convention of both parties to control of the elected office holders of parties who know the people they are voting for, rather than a primary electorate that is easily influenced by sound bites, previous fame, and irrelevant occupations. So with that somewhat heterodox view, my basic proposition is that we don't need more democracy, we need more indirect election.
Thanks. I think that's a fascinating perspective, and I'm not surprised that someone of of your learned quality would take us back in history in that way. So much appreciated. First of all, as to scholarship, you're quite right to invoke the work of Raoul Berger and William Rehnquist, both of whom wrote very extensively about impeachment. I would add one more to that list. My friend and current colleague in the Legal Academy, Frank Bowman, a professor at the University of Missouri, has written a wonderful book called High Crimes and Misdemeanors, A History of Impeachment for the Age of Trump, a very recent book that walks through this history. And I think that he would reach a somewhat different conclusion than the scholars who you mentioned, George. He looks at the history and says, we fundamentally misunderstand. I guess he's not necessarily quarreling with the standard high crimes and misdemeanors, but saying we should understand it to encompass more broadly unsatisfactory conduct in office. And then one would debate how unsatisfactory it has to be. As to the fitness of the last four occupants of the office, I guess I disagreed to some extent with you. I think several of them were quite good. And let me say one thing about President Obama. You're quite right to say that he wouldn't have emerged from the proverbial smoke-filled room. He certainly came from outside the establishment and didn't have a lot of political experience and had only been in the Senate for a short time. But in my perhaps biased view, I think he rose to the occasion in quite a dramatic way. One might remember that Abraham Lincoln had similarly sparse credentials when he became president in 1860, and he certainly filled the needs of the country quite well. Fundamentally, I guess I do have more faith in democracy than you do. I understand your points, but I think that democracy is what we are. We're not an Athenian democracy. We don't all raise our hands and count the votes of the citizenry to decide on legislation. And the Electoral College, of course, is a check against direct election of the presidents. I think the Electoral College is a flawed mechanism, but that's another talk, perhaps when we're back live in the library. But I think that democracy, it's unsatisfactory and frankly unacceptable as a matter of democratic principle that we should have a president who serves for 4 undisturbed years without the possibility of a meaningful possibility of removal, and yet he never attains majority support. So I think we need more democracy to remedy that situation. Let me encourage our audience members to pose questions. George, did you have any additional questions for me before we turn to our audience members?
I think in fairness to the audience, we should hear from them at this point.
Okay, let's CJ Pippins. Could you tell us what we should respond to?
Sure. All right. So the first question comes from Robert Morgan, and his question is, are you suggesting that there should be a remedy in the Constitution that allows for removal of a president because he is consistently unpopular?
I'm not sure. I must say I'm better at diagnosis than cures at the moment. Unfortunately, that's too true of our circumstances. But I see the flaws in the Constitution, and I'm not quite sure what mechanism I would propose if I were in 1787 in Philadelphia, or if there were a constitutional convention now and I were fortunate enough to be chosen as a delegate. I do think we need to somehow allow a safety valve, that somehow there needs to be an opportunity for the citizenry to be heard, perhaps through their members of Congress, to say the presidency is a failure. That, I must say, would not, even if you had a lower threshold than 2/3, and even if the standard was something different than high crimes and misdemeanors, I don't know that this Senate would have voted to remove this president. There's tremendous partisan loyalty throughout the country and on both sides. And it's clear, as we know, only one Republican senator, Mitt Romney, voted to convict the president on one of the 2 articles of impeachment. So we weren't even at a majority, much less a 2/3 threshold. The question is a good one, and I would answer in a more general way to say I wish the Constitution had more flexibility, as the European systems do. George mentioned Switzerland, but of course We see it in many European and countries elsewhere in the world, democracies elsewhere in the world, where we can have a mid-course correction. In my view, this presidency has been unsuccessful, and especially now in this emergency has proved to be disastrous, and therefore I wish there had been an opportunity to change course.
All right, now we have a question from Robert M. Bell. What is the authority for subjecting the chief judge to the rules of the Senate? As I understand preside, it means to be in charge, not hamstrung by the rules of the jury over which the presiding officer presides.
Well, first of all, let me say hello to my friend Judge Bell, Chief Judge Bell, former Chief Judge of the Maryland Court of Appeals. What an honor to have you listening to us, Your Honor. And I'm not surprised that you would defend the prerogative of the Chief Justice. If I could digress for a moment, one of the proudest moments that I've had as Dean of the University of Baltimore School of Law was when we opened our new building in 2013. And our speakers on that occasion included Chief Judge Bell and Justice Elena Kagan. It was my pleasure and honor to welcome them both to our school. So thank you, Judge Bell. It's a very interesting question. I'm not sure it's ever been tested. I do know this from my work in the Senate, that it's well established as a matter of Senate procedure that the body can overturn the ruling of the presiding officer. Now, the presiding officer under the Constitution is the vice president. That's an authority, a duty that's typically delegated to a junior member of the majority party in the Senate, and that's typically who's presiding. But if there's a ruling on a parliamentary matter, the body can vote. Someone can call the question, and the body can vote to overturn. That, and this is another digression, that is the mechanism by which the rules were changed to eliminate the filibuster of judicial nominees and other nominees, executive branch nominees as well. And I think that was unfortunate, but it happened because of the precedent that the body can overturn the chair and basically change the rules of the Senate in that way. Judge Bell asked the question, would it be different if the Chief Justice of the United States made a ruling and the body tried to overturn it? The Senate sets its own rules under the Constitution. The Senate establishes the rules of the body and the rules of proceeding here. It would be a fascinating constitutional conflict if Chief Justice Roberts had said, no, thank you, majority party, I'm going to do it my way. I'm not quite sure what would have happened at that moment. But I fear that the Chief Justice would feel that he was in the Senate chamber occupying the seat of the presiding officer, and the presiding officer can be overruled under Senate procedure.
I think if I may interpose for a moment, that at the Clinton impeachment trial, Chief Justice Rehnquist, in answer to a question from Senator Harkin, stated that the role of the Senate was not the role of the jury. In effect, was both the court and the jury. And this ruling was considered to be, in the context of the Clinton trial, an aid to the president, because it dispelled the notion that mere guilt of a crime was ground for impeachment. It seems to have been generally understood, and that ultimately was found in the court, that had proved himself for the grand jury. But the effect of the Chief Justice's answer was, in effect, to say to the Senate, you decide if that's grave enough. And of course, the Senate decided it wasn't.
Right. Now, you're right. You're right to recall the Chief Justice's ruling at that time. So I guess in each of the two recent impeachment trials, the Chief Justice exercised a little bit of the prerogative of a presiding officer, and in neither case was challenged by the full body. I don't know what would happen if Chief Judge Bell, if his question was tested by ruling of the Chief Justice as presiding officer that the body sought to overturn. They didn't seek to overturn Chief Justice Rehnquist's ruling that you mentioned, George, or the relatively trivial ruling that Chief Justice Roberts made with respect to Senator Paul's question. Other questions, CJ?
Sure. This one is from Louis Becker. Understanding evidence is essential to any trial or impeachment. Was there really a need for more evidence in the Trump proceedings, since many of the crucial facts were known and or conceded? Wasn't it more a question of judging what he did rose to high crimes and misdemeanors?
So first of all, I need to welcome one of my other favorite judges, Lou Becker, formerly active judge on the Howard County Circuit Court, and now a senior judge sitting all around the state, and a graduate of the University of Baltimore School of Law. So thank you, Judge Becker, for being with us. Great question. I don't think all the facts were known. And most specifically, if you remember, there was a key dispute about the president's motive in withholding aid. There was no dispute that he had withheld aid from Ukraine at a certain point. The allegation by the House was that he did so to, if you will, extort material from the Ukraine. He wanted dirt on one of his political opponents. But the president and his defenders argued that he had perfectly sound motives for withholding aid, that he wanted to make sure that the aid would be well spent. And a key witness to that dispute would have been former National Security Advisor John Bolton. Bolton at first refused to testify. The House had subpoenaed him and then tried to enforce that subpoena, but ultimately withdrew that suit. And so the courts didn't decide whether Bolton had to testify. Then Minority Leader Schumer tried to have the Senate subpoena him, and that effort was thwarted by the majority party. Ironically, Mr. Bolton is going to speak because he's one of the speakers for the Stevenson University Speaker Series here in Baltimore. I guess it's going to be virtual rather than live, but I've seen the advertisements for it, and I, for one, very much look forward to hearing what John Bolton has to say, but I think he should have been compelled to say it in the context of the impeachment trial. So that's one bit of evidence that we didn't know, Judge Becker. I think there were others. There were documents that might have shed light on the circumstances of the withholding of aid, different conversations that were in dispute that some witnesses might have been able to illuminate. So you're quite right that much was known, but not all. I don't know whether that would have changed the outcome. Probably not, in a system that I fear was designed to fail. But I think it would have been a fairer and more a fuller, comprehensive proceeding if we'd heard that evidence.
I might say on that point, I agree with Dean. It seems to me that the most serious flaw that transpired was the thwarting of discovery. And Philip Kurland, who was one of my mentors in law school, made the same point about the Watergate investigation. There was a ruling by Judge Gerard Giselle that allowed greater scope for the independent counsel investigation than for the congressional investigation which preceded it, which Kurland thought got precisely backward. And I think part of the blame for what happened does rest with the managers on the part of the House, who should not have taken no for an answer as far as the privilege claims were concerned, even if the result had been some delay, and even if the result had been that the privilege claims had to be litigated all the way to the Supreme Court. Because it seems to me the real office and function of impeachment is less removing the president from office than holding him publicly accountable. And the first and greatest of impeachment, not the first and greatest of it, was the impeachment of Warren Hastings.
Yes. Would you permit me to say a word about Hastings, if you'll permit? Hastings was the Governor General of India when it was a British colony. And his impeachment was ongoing at the time of the Constitutional Convention. So the framers of our Constitution were very familiar with the impeachment mechanism. It's actually a very important precedent for the proposition that high crimes and misdemeanors doesn't need criminal conduct, because Hastings was, the phrase high crimes and misdemeanors was used in his proceeding And the allegations were essentially that he was an incompetent and overbearing administrator as a colonial governor. And ultimately he was acquitted, but that's not so relevant because that occurred after the Constitution, our Constitution, was ratified. But you're quite right, George, to say that impeachment is a mechanism for holding the president more accountable, even if he's not to be removed. You can kind of see it as oversight on steroids. But if so, then surely the House or any congressional committee engaged in oversight needs to have the power to compel evidence. We'll see. There's a case working its way now through the courts. The D.C. Circuit is hearing a case in which the House seeks to enforce its subpoena of Don McGahn, the former counsel to the president, more in relation to the Russia investigation. But the House has asserted in that litigation that they need to decide whether to draft new articles of impeachment against the president based on McGahn's testimony. So we'll see.
The important thing about the the Warren Hastings impeachment, even though he was acquitted, was that it basically transformed the government of British India and allowed British rule to survive for another 2 centuries, which probably wouldn't have otherwise. And it may be the importance of Trump's impeachment, abortive though it was to send the message loud and clear that politics is supposed to stop at the border's edge, and that we don't want people messing around with foreign governments in law enforcement matters. We don't want Trump doing it, and we don't want Biden doing it either, which he was alleged to have done. It's unseemly and wrong. And I think that may be the enduring message.
I hope you're right, George. The question is, who's hearing that lesson? Maybe future presidents, but this president, at least in his public statements, appears to be emboldened. He calls the acquittal an exoneration and continues to call his interactions with the president of Ukraine perfect. So I'm not sure he's hearing the lesson that you think was delivered, but maybe future presidents would be, and I hope so. CJ, other questions?
Sure. Howard Shulman asks, would not some of the issues raised by George be addressed by eliminating open primaries, not party bosses at conventions?
Yes, maybe George should answer, but that does seem to me to address some of George's concern about excessive democracy. What do you think?
There was a compromise at one point because when the primaries were introduced, originally most of them were just beauty contests. They didn't delegate. They were really advisory. And they weren't necessarily decisive. In 1912, William Howard Taft lost most of the primaries and won the nomination. And of course, Theodore Roosevelt part of the third party. But and there have been other occasions where that happened. In 1952, Adlai Stevenson didn't enter any primaries. And the convention was afraid of Estes Culver, who was known to be a rather enthusiastic consumer of alcoholic beverages, and didn't nominate him. But if I had a vision of the future under the dean's standard, it would be of the dean sitting in an auditorium at the University of Baltimore Law School, surrounded by several hundred crowd-immune students, with a large bowl of popcorn, witnessing the fourth in a series of presidential impeachments of people who were nominated in the first place.
Well,
that's
first of
what I have.
first of all,
the end is bad; it's that the beginning is bad.
Yeah. First of all, I hope we are back in the law school building soon, and I hope there's popcorn there when we get there. I need to be careful here. I'm not suggesting that impeachment should be an everyday occurrence. I'm not saying it should be mere unpopularity. I just think the framers set the bar too high, and the 2/3 threshold, I think, is too high. It's really unattainable. I think it should be more like majority support, which, of course, would turn then on whether the president's party controlled the Senate or not. And in this circumstance, where you have a Republican-controlled Senate, we would be unlikely to see a Republican president removed.
Don't you think Nixon might have been convicted had he not resigned?
Yeah, of course, what we saw there, that's right. Famously, Barry Goldwater and other leaders of the Republican congressional majority went to Nixon and said, it's time to go. He was losing Republican support in the Senate. Howard Baker and others were real profiles and courage in turning on a president of their own party. As I said earlier, in history, there's only one senator who's ever voted to convict a president of his or her own party on an impeachment vote, and that was Mitt Romney this time around. CJ.
All right, so this is an anonymous question. You advocate a mechanism for removal based on polling. This appears to be equivalent to a popularity vote for the president, negating the Electoral College. Is this not a concern, even more so when polling data is at times woefully inadequate?
Yeah, it is a concern. I think maybe that if I sounded to be saying that, I'd like to withdraw it that way. I don't think the president should be removed on polling. I think the president should be removed through more indirect mechanisms, probably congressional. My point about polling was simply the constitutional structure erecting very high walls to the president's removal is so troubling in the current circumstance where we have a president who has not attained majority support on a single day of his presidency, according to an aggregate of polls, not any single poll, but the website 538 aggregates all the national polls. And he hovers around 42, 43%. Sometimes in the immediate aftermath of the virus outbreak, he was up to 48%. He's never gotten majority support. But I don't think that polling should be the sole criteria. I think it should be a judgment by elected officials on a lower standard, a somewhat lower standard, and a different threshold.
You must recall, though, that Harry Truman, for the last 3 or 4 years of his presidency, was polling in the 20s.
Yeah, and that's right. And George W. Bush was in the 30s for a time, and Jimmy Carter. But presidents, if you look through history, and polling, of course, has become more sophisticated over time, but presidents are up and down. There's never been a president without majority polling support throughout his entire presidency in any time since there's been polling. CJ?
Robert Levin asks, if it were in fact the case that the president grossly mishandled the pandemic, subjecting tens of thousands of citizens to death and causing catastrophic harm to the economy, would that be impeachable conduct, or would it be maladministration of the sort that the framers rejected as the standard for impeachment?
I was hoping for that question because I wanted to tell you the story of the Duke of Buckingham. My colleague, Professor Bowman, tells this story in his book that in 1626, there was an impeachment proceeding in Parliament of the Duke of Buckingham. And one of the articles of impeachment was that he had encouraged the king to take unnecessary medicine and therefore impaired the king's health. That impeachment was not successful, but I thought that had a modern echo that was very interesting and noteworthy. As to this president and whether, I certainly don't think that he has caused the pandemic. I want to be quick to say that. He certainly has not. I do believe he's mismanaged the federal government's response to it, but he's not responsible for the circumstances that we're in. It may be that there were other things that could have mitigated the harm, that steps that were not taken early on. I don't know which standard it satisfies. In my mind, it clearly satisfies the standard of maladministration. Would it satisfy the standard of a high crime and misdemeanor if we understand that standard to not be limited to criminal conduct, but rather to be some notion of malpractice or maladministration? Perhaps so. As I said earlier, I do not advocate the impeachment of President Trump at this stage of his presidency and during the pandemic. I think that would be unwise and bizarre, frankly. Rather, the remedy, to my mind, is the election in November. CJ? Oops, you're muted, CJ.
There we go. Sorry about that. The next question comes from Alan Garton. Former FBI Director Comey has faced criticism from both parties. Mueller's investigation received tremendous attention. Some persons surrounding Trump have been convicted and are in jail or out for various reasons. Trump has hinted that he will pardon some of these persons. Please give us your comments on Comey's actions, the way the Mueller investigation was handled, and the possible pardons of Roger Stone, General Flynn, Paul Manafort.
Well, thank you to my friend Alan Garten. The Garten family is very close to the University of Baltimore School of Law, and Alan is a graduate, so thank you, Alan, for being here and for that question. We're a little bit afield from impeachment, but I'll give you my view. I know Jim Comey. I didn't work with him directly, but I was in the Justice Department both at a time after he left and then before he came back as FBI director, and I know of his reputation. I think he made some mistakes in how he handled the Hillary Clinton email investigation. I think he made a mistake in publicly exonerating her in the way that he did, and then found himself needing to come back just days before the election in 2016 to announce that there was new evidence that was being scrutinized. And I think for many of us underlined the danger of the Justice Department and certainly the FBI director commenting on a pending investigation or an investigation that did not result in criminal charges. So I think Jim Comey made some mistakes, but he was entirely well-intentioned. And I think he's a fine public servant. And the criticism that he's received from the left and the right, he knows is, the price of being in a public role. And while he probably would reconsider some of the decisions that he made, and he speaks about this in his book, A Higher Loyalty, I think history will judge him well. So that's my view on that. As to the pardons, I think it would be outrageous for the president to pardon his political allies after the proceedings that have occurred. I would be quick to note that other presidents have done it. George W. Bush, Bill Clinton pardoned a number of people under very questionable circumstances. The pardon power, which is unlimited in the president, is subject to abuse. And I think other presidents made bad judgments, and those individuals, in my view, should not be pardoned because they engaged in wrongdoing and should pay the price. CJ, any more coming?
All right. One more. This comes from John Connolly. Can you compare the removal of the president or of a judge by impeachment with the expulsion of a member of Congress by one of the houses of Congress? Does the latter system work better as a practical matter?
Right. Expulsion from Congress is very rare, but it does happen. And it's happened in both the House and the Senate. Adam Clayton Powell was removed by that mechanism. Jim Traficant from Ohio was removed by that mechanism. Harrison Williams, senator from New Jersey, who got caught up in the AppScan investigation, was expelled, or he might have, I may be wrong about that, he might have resigned just before his inevitable expulsion. Of course, that's a remedy for the houses of Congress to cleanse themselves. It does involve a substantial evidentiary proceeding. The ethics committees in each of the bodies, which are very serious committees, very committed to their roles, will typically have lengthy evidentiary proceedings and give attorneys for the members an opportunity to cross-examine witnesses, and then a report is issued that the full House considers. I have seen that proceeding occur in my time in the Senate, and I think it works very well and has caused some people who didn't deserve to hold the office to be removed from office. So that, I think, is a sound and proper procedure and works better than impeachment. I think we're done. Is that running through the question, CJ?
That's it.
That's good. And Mr. Liebman, any final words from you?
Well, I just want to thank our guest for a very provocative discussion and also for his tolerance for my heretical views.
I love your heretical views.
But I think this is the sort of thing that we hope to do more of at the Bar Library. And we hope to have more discussions of current issues that may be controversial current issues, which this is one. And we have had a large number of speakers, but the speeches tend to be soliloquies. And format has something to recommend it. I hope I haven't unduly distressed the dean by...
Not in the least. No, first of all...
as a teaching mechanism.
Right. First of all, I want to thank you for providing this platform and inviting me to participate. As I said, I only regret that we're not in your beautiful library where we could enjoy hors d'oeuvres after this talk. But I appreciate the opportunity to be with you. And I thought, just as my remarks were intended to provoke thought, your response was appropriately provocative, and I welcomed it. And you and I could have a longer conversation, I'm sure we will sometime, about these important issues. So thank you so much. And I'm sure you'll join me, George, in thanking our participants, our audience members. I thank my colleagues, C.J. Pippins and Chris Stutz, for helping us, your colleague, Joe Bennett, and Francis Bennett for helping set this up. And we'll continue this discussion, hopefully in person, when life returns to normal. Thank you.
All our members know the indispensable role that Joe Bennett has played in the history of the last 30 years of the library.
Absolutely.
This evening, because of my complete technological ineptitude.
You're doing fine, George. Thank you all very much.
Thank you, Dave. Thank you.